More suspects charged in a mass shooting at a Catawba County home are due in court this week. Keandre Mack is scheduled to appear at 10 o'clock this morning. Charles Kincaid is expected to appear this afternoon at 3. 5 other suspects are scheduled for their appearances in court tomorrow. In total, 6 suspects are charged with 63 counts of attempted murder, one for each person investigators say were in the line of fire during those attacks on June 1st, 2025.
A 7th suspect is facing an accessory charge for claims that she helped drive some of those suspects from the scene. One person was killed, 11 others were hurt when gunmen opened fire on that pool party last June.
All right, so let's bring in our chief legal analyst, Colleaf Rhodes. Tell us about where we're at in this process, because a lot of people think this takes a long time, but there's a lot to go through.
It is a long time, and so I tell every client that I meet with a homicide case that the lifespan time frame for the moment that you meet me to some resolution, that's either a plea deal or a trial, is 3 to 5 years, and that's in Mecklenburg County. Some of these other counties are a little bit faster, but I'd say that's a good range, and for a number of reasons. You need discovery with a case like this where you got 63 people that were there. Detectives will need to talk to everyone that's at the scene to try to complete their case, and so I had a case where we had 5 co-defendants, and there were a number of folks similar to this with, maybe 100 people outside. There was maybe 20 to 30 officers that appeared, so you're talking about 20, 30 different body cams. You're talking about 20 different written statements. I mean, when they gave me my paper discovery, it was probably 8,000 pages of reading. That documentation has to be compiled, and so it goes from the detective to the lead prosecutor. The prosecutor will review it. That may take 6 months. It could take 8 months. Then they'll give it to the defense attorney. Then I'll have to review it with my client. And so that process alone, just the beginning of a case, could take a year and a half before you can now tell the court, hey, we're ready to do something with this, either accept some type of plea or go to trial. And so that's why they can take an extremely long amount of time. I mean, because you just got a lot of people to talk to, and officers, detectives want to make sure they did get this right. And so you want to ensure that you have the right people to charge, and you want to make sure that you didn't miss anything.
Speaking of charges, as all of this unfolds, right, with all these different suspects, if a court finds that there was gang activity or planning was involved, does that change and up possible charges for any of these suspects?
Not up charges, but up sentencing. And so in North Carolina, we have something called, we have structured sentencing. And so for a case, you could start within something called the presumptive range. That's the middle. And then you can either downward departure to the mitigated range, and that's if you find something in their background like substance abuse, mental health issues, things like that. But you also can go to the aggravated range if you find something like children being involved or gang-related activity. There are a number of factors that are there that can get you to go one way or the other. I can argue on my side for mitigated ranges why, hey, Your Honor, court, you should accept our mitigated plea. But on the other side, that the state may say, hey, we have this list of 12 or 10 factors in gang relation. It's probably one of them that we can say now the court should bump this up to the aggravated range. And we kind of do decide that before we present it to the court if it's not an open plea. If it's an open plea, which is extremely dangerous on the defense side, then the court can make their own determination if they'll go up or down. So typically you want to have that decided before you get to court with both defense and prosecution. And hey, they're going to serve these proposed aggravating factors on me and let me know, hey, this is what we're alleging. So yes, gang activity could be one of those.
This was a high profile case in our area, of course, obviously for the seriousness of what these young people are accused of. Where do you see this going? Do you see them taking some sort of plea deal or going to trial for all of these young people?
It's going to be fact specific. That's the first thing I'll say. If you're someone that's like, hey, I was not there, that wasn't me, you're going to trial. You're not going to take a plea that's connected to this, because most of the pleas will probably be in that manslaughter range, or the range of a C or D, I should say, in terms of sentencing range, which you don't want to do if you weren't there. This is your first offense, if it's a C, that's still 7 years. That's a long time to go to prison for something that you were not there. But if you genuinely don't have an alibi, if you genuinely don't have a defense to this, sometimes plea is the best alternative, because on the other side, you're sitting and looking at significant time that could possibly run consecutive and not concurrent. So now you're stacking these dates on top of each other. Those 7 years start to add up over time.
There are hearings today, there are hearings tomorrow up in Catawba County, and if you said this could go anywhere from 3 to 7 years, we're going to be talking about this
Typically
for
3 to
quite
5,
some time,
but
3 to
definitely a
5.
long
Okay.
time.
All right, Khalif, thank you very much. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.